Good day, Piscal. Good day, classmates. I'm Ray David T. Enriquez. My report covers the third part of our report on Republic Act number 8749, an act providing for a comprehensive air pollution control policy and for other purposes. This act is known as the Philippine Clean Air Act of 1999. So, my report primarily focuses on the regulatory aspect of RA 8749, which I will discuss later on. However, before we proceed further with my discussion on my report, I would like to reiterate some important information that I know that we already know since high school. So, these are the sources of air pollution. So, the sources is divided into two. So, the natural sources and man-made. So, when we speak about natural sources, from the word itself, it is natural, so it occur without human intervention. So, an example of this is the lightning, volcanic eruption, wildfires. Ayan, so those are the natural sources. So, while the man-made sources, uh, it may it may go in different areas. For example, the area sources, the stationary sources, the mobile sources. So when we speak about area sources, it pertains to a specific area, a pollution from the specific area. For example, in your home, in your house, you are using chimney while cooking. So that chimney produces air pollution that contributes to our pollution. Okay? And then we also have mobile sources. So we are very familiar with this because we most of the time we are using it. Okay? For example, uh cars, um motorcycles, buses, airplanes, ships. However, ships are already using modernized technology to lessen the emission of pollution. Okay? So, the next one is the stationary sources. So, I intentionally made this last to discuss because this is the primary focus of my report. So, stationary sources comes from the uh, pollution coming from the fixed location. So, usually, unlike the mobile sources, stationary sources doesn't move. And unlike area sources, stationary sources emits much air pollution than area sources because in area sources they may be a small air pollution, but in stationary sources it is much bigger. Uh, it it contributes bigger than the other sources. Why? Because one example of this is the factories. Okay, so another example is the power plants, refineries, and incinerators. So there are many. These are the big plants that contribute to our pollution. And why it is the topic of my report because usually stationary sources subject to the permits and regulations by the government because they contribute a lot to the pollution. Therefore, it must be regulated. It must be monitored. So that is why my topic is about administrative action involving stationary sources. Okay? So it is provided under the law that if someone violates air quality standard provided therein, or if someone disobeys orders, rules, or regulations issued by the Department of Environment and Natural Resources or DENR, then the DENR itself may take an action or have the power to take action to initiate their own suit against the company or the factory, or there is someone that would voluntarily surrender himself and courageously file a complaint against the factory or a company. So Ayun. Those are the administrative action involving stationary sources. So again, it may be filed in two ways. First, by the initiative of the ENR, and the other is the initiative by other person or upon complaint of other person. So according to the law, the Pollution and Adjudication Board, or PAB, shall have the sole and exclusive jurisdiction over all cases of air pollution and all matters related thereto, including the imposition of administrative sanctions, except as may be provided by law. So while reading the textbook that was given to us, I encountered one of the cases, and I think this is very important because the it provides doctrines for us to understand. So one of the doctrines is that action for the abatement of a private nuisance lies with the courts, not with the PAB nor the Sangguniang Bayan. So in this case, my dear friends, the uh, there is an issue regarding the uh, air, air-cooled type air conditioning units from a 29-story commercial residential condominium. And it emits air pollution and noise to the residents. So, uh, they filed an action. So, the issue in this case is whether the, who has the jurisdiction over an action for abatement of noise and or air pollution and damages, with a plea for injunctive relief emanating from the air-cooled type air conditioning units from a 29-story commercial residential condominium. So the question is it the Sangguniang Bayan or the PAB or the courts? So the court ruled in this case is that the abatement of nuisance rests with the courts. Thus, we agree, according to the court, petitioner's contention under Section 447A, Paragraph 3, I, of RA number 7160, otherwise known as the Local Government Code, the Sangguniang Panlungsod is empowered to enact ordinances declaring, preventing, or abating noise and other forms of nuisance. Okay? However, that the Sangguniang Bayan cannot declare a particular thing as a nuisance per se, and other is condemnation. It does not have the power to find as a fact that a particular thing is a nuisance when such thing is not a nuisance per se, nor it can authorize the extrajudicial condemnation and destruction of that as a nuisance which in its nature, situation, or use is not such. So those things must be determined and resolved in the ordinary course of law. So another, the Pollution Adjudication Board has no primary jurisdiction over the noise complained by the respondent. The resolution of the issue before the RTC, which is whether the noise complained of is an actionable nuisance, does not require any special technical knowledge, expertise, and experience of the PAB or even Makati City, requiring determination of technical and intricate matters of fact. So, what the case tells us is that, for example, suppose there is a faulty farm operating within the municipality. So, the Sangguniang Bayan passes an ordinance that regulate noise, foul odor, di ba, pagka may poultry, mabaho po yung amoy. So, and sanitation standards. Uh, so the problem here is that whether the poultry farm is a nuisance per se. Because the residents on that area filed a complaint that the poultry farm is so very uh, noisy and smelly. It has foul odor. So the problem is that the poultry farm nuisance. So the answer on that question is that uh, no, the poultry farm is not nuisance. because although the local council can regulate and pass ordinance, it cannot unilaterally declare and demolish the farm because the determination should be based not on the Sangguniang Bayan but before the courts. So it needs judicial determination. If the residents wants to destroy the farm because it caused noise and smelly odor, then they should file a case before the courts, not only complain before the Sangguniang Bayan. Okay? So let's proceed. Action before the LTO. So as I mentioned earlier, there are also mobile sources. So LTO is one of the agency that regulate the emission of pollution among the mobile sources. So according to LTO, actions for any according to this law, actions for any violation of the motor vehicle pollution control may be commenced by any person filing a written complaint or by the DOTC on its own initiative or by filing of a charge by a deputized agent of a DOTC before the hearing officer. And it must be noted that the proceeding shall be summary in nature. The rules of course shall not apply except in a supplemental character and only whenever applicable. So as to the decision, if the respondent admits a charge, the hearing officer shall issue an order imposing the appropriated fines and directing the grounding the apprehended motor vehicle. So upon the presentation of the official receipt certifying full payment of fines, shall the grounded vehicle be released and resumed to operation. So another case is that Henares versus LTFRB. So in this case, petitioners argued that uh, since the DOTC and LTFRB regulate public utility vehicle and know these vehicles emit harmful pollutants, they should be compelled by mandamus to address the problem. Specifically, require them to use compressed natural gas or CNG as fuel. So according to Solicitor General, the DOTC's role is only to enforce emission standards under the Clean Air Act. The law merely sets maximum emission limits and it does not mandate CNG or any alternative fuel. So if the petitioner wants CNG to be used compulsorily, then that's the policy that should be made by the Congress and not to the agency of LTFRB. So the issue in this case is whether the respondent is the agency responsible to implement the suggested alternative of requiring public utility vehicle to use compressed natural gas, and second, whether the respondent can be compelled to require public utility vehicles to use compressed natural gas through a writ of mandamus. So the court ruled that mandamus is available only to compel the doing of an act specifically enjoined by law as a duty. Here, there is no law that mandates respondents LTFRB and the DOTC to order owners of motor vehicles to use CNG. At most, LTFRB has been taken by EO number 290 in paragraph 452, section 4, to grant preferential and exclusive certificates of public convenience or franchises to operators of NGVs based on the results of the DOTC surveys. In addition, under the Clean Air Act, it is a DNR that is tasked to set the emission standards for fuel use and the task of developing an action plan. On the second issue of whether the respondent can be compelled to require public utility vehicle to use compressed natural gas through a writ of mandamus, the court ruled no. petitioners are unable to pinpoint the law that imposes an indubitable legal duty on respondents that will justify a grant of the writ of mandamus compelling the use of CNG for public utility vehicles. As I mentioned before, the legislature should provide first a specific statutory remedy to complex environmental problems barred by herein petitioners before any judicial recourse by mandamus is taken. Okay, so now let's go to citizen suit. So we are very familiar with this. So any citizen may file an appropriate civil, criminal, or administrative action in the proper course against any person who violates or fails to comply with the provisions of this act or is implementing rules and regulations, or the department or other implementing agencies with respect to orders, rules, and regulations issued inconsistent with this act. So what this statement is telling us is that any person may file an appropriate civil, criminal, or administrative action. So any public officer who willfully or grossly neglects the performance of an act specifically enjoined as a duty by the law, or is implementing rules and regulations, or abuses his authority in the performance of his duty, or in any manner improperly performs his duties under this act, or is implementing rules and regulations. However, no suit can be filed until after 30-day notice has been given to the public officer and the alleged violator concerned, and the appropriate action has been taken thereon. So, what this provision is telling us is that, again, any citizen can go to court as to private violators, any person or company that breaks the Clean Air Act or is implementing rules, or IRR, may be sued. And if someone violates the mandate of DNR, then that someone can be also sued. And also, the public officer who willfully or grossly neglects the performance of an act under the Clean Air Act, then that officer can also be sued. So those are the statements provided here in this particular provision. So the filing of an administrative suit against such person or entity does not preclude the right of any other person to file any criminal or civil action. So, if someone was sued due to the poor performance of the duty, then the other person who also wants to file a suit can also be considered by the court. Now, what is the procedure for environmental cases? So, on April 29, 2020, the Supreme Court passed the landmark rules of procedure for environmental cases, which allow for a citizen suit. So again, as mentioned earlier, citizen suit, anyone can file a case against any person who violated the provision of this act. Okay, so as provided under the rules of procedure, any Filipino citizen in representation of others, including minors or generations yet unborn, may file an action to enforce rights or obligations under environmental laws. Upon the filing of a citizen suit, the court shall issue an order which shall contain a brief description of the cause of action and the reliefs paid for, requiring all interested parties to manifest their interest to intervene in the case within 15 days from notice thereof. So, I know we are very familiar with this. So, we already encountered this provision when we discussed the case of Ooposa versus Pactoran in constitutional law when we were in first year. So, Ayan, I'll discuss that later on. So, one of the cases, aside from Ooposa versus Pactulan, I'll discuss that later. I'll give you a brief discussion. So, in case of marine mammals versus Reyes, so we are also very familiar with this because this was tackled when we were in first year. The main problem in this case is the locus standi. So, the court held in this case that the marine mammals cannot be recognized as real parties in interest. Why? Because they are not rational. Okay? So, they cannot be sued on their own name. So, however, since humans are rational being, therefore, the court said that a citizen may file a suit against those person who violates ecology on the grounds that uh, every person has a constitutional right to a balanced and healthful ecology. Therefore, every person have a legal standing. So this was also the same. That ruling is also same with the Oposa versus Pactulan case. So the court said in this case that dolphins and whales don't have direct legal personality, but human petitioners can sue on their behalf to protect the environment. So that is the lesson on this case, the doctrine. Now, in the case of Oposa versus Pactulan, so just a brief background. So in this case, petitioners sought to cancel all existing timber license agreements and stop the DNR from issuing new ones. Why? Because it affects the environment. Okay? So they invoke their constitutional right also into balance and healthful ecology under Article 2, Section 16 of 1987 Constitution. So, the one of the issues in this case is that whether the minors have a legal standing to file a case. So, the court ruled that yes, minors have a standing not only for themselves but also for future generation. So, this was doctrine of what we call intergenerational responsibility. Okay, so how the minors file a case? So, they are of course represented by by their guardians or parents. Okay? So, suits and strategic legal actions against public participation or SLAP and the enforcement of the act. So, this particular provision uh, pertains that because sometimes when citizens or public officials enforce environmental laws, the violators strike back by filing harassment cases. So, this is just a safeguard if a case is filed against a person who filed an environmental action under Section 41 or what we call a citizen suit or against a public official which implements the Clean Air Act. So, according to this provision, the prosecutor or the court must check within 30 days if the case was filed just to harass, pressure, or silence them. Okay? So, if the prosecutor found that there is an harassment against the public official or person who filed an environmental action, therefore the case should be dismissed. And the person that was harassed will be awarded attorney's fees. And there are also special protection for public officers. If the officer was acting in good faith within their official duty and without grave abuse of authority, then they can be punished through retaliatory suits. Okay? There are also fines and penalties imposed pursuant to this act. So, it shall be liens upon personal and movable properties or of the violator. So in this provision, uh, it only gives us the daily fines for violation. So if a factory or other stationary source exceeds pollution standards, so according to this law, it gets fined up to 100,000 per day. Five but not more than 100,000 for every day of violation against the owner. So who imposes this fine? So it is the DNR, Pollution Adjudication Board, that imposes these fines. So they create a fine rating system to make the penalty fair but effective. So what is the basis of the fine? So the basis is of course, depends on the ability to pay of the corporation, degree of willfulness, degree of negligence. So if there is carelessness on the part of the corporation or the company, then much fine will be imposed. So if there is a history of non-compliance, if uh, there is a negligence but not willful, then there is a minimal fine. So that's the essence of this provision. Okay. So the fines herein prescribed shall be increased by at least 10% every 3 years to compensate for inflation and to maintain the deterrent function of such fine. So it fines are this law also considered inflation in imposing fines. Okay. So, violation of standards for motor vehicles. No motor vehicle can be registered with the DOTC unless it meets the emission standards set by the department as provided in Section 21 of this Act. Okay, any vehicle suspected of violation of emission standards through visual signs such as but not limited to smoking, belching, shall be subjected to an emission test by a duly authorized emission testing center. So, for those who have a car, uh, and renew their registration yearly, then you may experience how the you may observe how the car was being tested by the authorized testing center to see if your car already produces much pollution as normal compared to the normal cars. So, for this purpose, the DOTC or its authorized testing center shall establish a roadside inspection system. Should it be shown that there was no violation of emission standards, vehicles shall be immediately released. So, if upon checking by the testing center that your car is not giving much pollution or there is your car is still in the normal state, then your vehicle must be released. So, according also to the provisions of the law, a pass shall be issued by the OTC to authorize the use of motor vehicle within a specified period that shall not exceed 7 days for the sole purpose of making the necessary repairs on the said vehicle. So those happen when uh, uh, the testing center or the OTC observe that there are defects on the vehicle. So in that case, the owner of the vehicle shall be required to correct its defect and show proof of compliance to the appropriate pollution control office. So before the vehicle can be allowed again to be driven by you or the owner of the vehicle to any public and subdivision roads. So there are also table of fines under the law if a vehicle caught violating emission standards. So, for example, you cheated on the testing of uh, emission of your car. Therefore, you are liable for penalties. Okay, for a fine. And of course, seminar should be there should be seminar for for violators. For example, and the driver and operator must attend pollution control seminar by DOTC. And there are also fines. First offense up to 2,000 fine. Second offense 2,000 to 4,000 fine, and third offense 1 year suspension of vehicle registration plus a fine of 4,000 to 6,000. So for inspection centers and technicians, if the inspection centers or technicians under the National Inspection and Maintenance Program cheat or fail to comply, then they can also be fined by 30,000 pesos. And of course, their license can also be cancelled because of that. And also, as to the law enforcement and deputized agents, so uh, these people who conduct emission tests and apprehend violators must undergo also mandatory training on emission standards. Because how can you regulate if you do not know what should be regulated? Okay, under the law, for any violation of the act, there is a fine of ranging from 10,000 to 100,000 and an imprisonment of 6 months to 6 years, both fine and imprisonment. So this applies to individuals and corporations, by the way. So if the violator is an individual, that person directly faces the fine or jail in time. So if the violator is a juridical person, the corporation, the penalty does not just vanish into thin air. Instead, the responsible officers are held personally liable. So these are the president, manager, directors. Ayan. So, ayun. So in this provision, what counts as gross violation? So the law defines it clearly. So when we speak about gross violation, it pertains to three or more specific offenses within 1 year under this act. And B, three or more specific offenses within 3 consecutive years. And C, blatant disregard of pollution adjudication board orders. For example, breaking seals, padlocks, operating despite cessation order. Ayun. Letter D, causing irreparable or grave environmental damage as a result of violating or omitting compliance with the act. So, when speak about gross violation, when speak about gross, it means repeated, deliberate, or extremely damaging violations, not just minor or isolated infraction. So, it is repeated, deliberate, and extremely damaging violations. And of course, penalty 6 years to 10 years. Imprisonment. Ayan, if juridical person like corporation, the responsible officers like president, managers, directors, trustees, pollution control officer, or official directly in charge are personally liable. Okay? Now let's go to Joint Congressional Oversight Committee. So, under the law, a Joint Congressional Oversight Committee is established. So, it composed of 5 senators plus 5 representatives appointed by the Senate President and the Speaker of the House. So, it is led by the uh, one senator and one representative designated by the Senate President and the Speaker. So, the purpose of this is to monitor the implementation of the Clean Air Act and ensures that executive agencies like DNR, DOTC, DTI, etc. are doing their part. So they can also recommend legislative refinements if gaps of a problem appear in the enforcement of the law. Okay. So implementing agencies. Of course, the department is the primary government agency responsible for the implementation and enforcement of the act. So it has rule-making power. The DNR can issue rules and regulations to carry out the intent of the law or the act. So example is the setting emission standards, monitoring procedures, and compliance requirements. Letter B, of course, DNR may have the supervisory function. So DNR should closely supervise implementation of air quality action plans. So this continued even on the LGU, which must implement in themselves uh, the enforcement of this act. And also the use of science in airshed designation. DNRs must revise the designation of airsheds using eco-profiling and scientific studies. Of course, uh, we cannot uh, regulate air except through science. Okay? And D, declaring non-attainment areas. DNR designates non-attainment areas, places where air pollution already exceeds safe standards. So you may observe, for example, even in the other states, that, for example, there is a radiation. So DNR may put a mark or put a pa- uh, fence on that particular area to prevent the exposure of people on the infected area which have radiation, because it is detrimental to the health of the people. And also, the NR may later revise the designations after consulting the LGUs, NGOs, POs, and other stakeholders. Okay, so if there are any questions, so I will not be able to be present on the meetings. But if you have question on our report regarding Republic Act number 8749 or the Clean Air Act of 1999, feel free to message us on our messenger account. Okay, so this is the end of our report, and hopefully we will pass this subject peacefully and prayerfully. Thank you everyone for listening. Thank you po, Fiscal. Uh, Thank you po, everyone.